Okay, now there's a huge disadvantage of filing for bankruptcy or a circumstance in bankruptcy in that bankruptcy cannot address and get rid of or erase or forgive liens that you have on your secured debt. So if you bought a home and you have it pledged the home as collateral through a deed of trust or some other mortgage instrument, or if you financed a car and you gave a lien in the motor vehicle recorded with the Department of Motor Vehicles on a timely basis, or if you've purchased appliances, furniture, jewelry, electronics, major durable items and consumer goods from an institution that then finances. It's called a purchase money security interest. If you finance the appliance at the creditor where you bought it, it's a good bet that they have a security interest in that property. And liens survive bankruptcy. That's just one thing that hasn't changed for over 110 years in the American bankruptcy system. So whereas your personal liability on the debt is discharged, forgiven, erased, the promissory note that you signed, the underlying lien is still something that the creditors can enforce through foreclosure or through some other non-bankruptcy right that they have under the promissory note that you signed when you took out the debt. Or under, I'm sorry, not the promissory note, because the promissory note is extinguished by the bankruptcy. I should have said under the security agreement. And that means the deed of trust or mortgage on your home. That means the security agreement on however you pledged the collateral when you took out and purchased the piece of secured property. Now, when it comes to secured creditors, the most basic secured debt is where you have what's called a non-possessory security interest. That means the creditor that lent you the money to buy the car, the furniture, the electronics, or the appliances, they don't have possession of the debt. They allow you to keep possession of it, but if you ever fail to make the payments, they can repossess or take control of those assets. If you file a bankruptcy and you discharge your mortgage in bankruptcy and you don't reaffirm on the mortgage, as long as you keep the mortgage payment current, you can still keep that home. As long as you keep the payment current on secured personal property, you're going to be able to keep that asset. Now, with cars, it's gotten a little bit goofy since the 2005 amendments or bankruptcy law changes, and that is, in a Chapter 7 bankruptcy, you either have to surrender the car to the creditor, redeem the car, that means pay the fair market value in a lump sum, or you have to reaffirm on the debt, which means put yourself back on the hook for the obligation. If you reaffirm on the debt, that simply means that the promissory note that is being discharged by the bankruptcy proceeding springs back to life and you still owe that promissory obligation. It's real important that on motor vehicles, when you go through bankruptcy, that you speak with your bankruptcy attorney in great length with regard to your desires with regard to the vehicle and also with regard to your financial and legal responsibilities if for some reason you run into trouble after bankruptcy and you have reaffirmed on the debt. Please, with regard to these secured debt issues, schedule an appointment to meet with an experienced, qualified consumer bankruptcy attorney as soon as you can.